So let's begin now with first the principle of equitable and reasonable use. And that's one of the two cardinal principles of international water law, together with the no harm principle. Interesting or of note is that the principle of equitable and reasonable use only exists in this formulation in international water law. So the other principle, the no harm principle, is a principle that applies more generally in international environmental law. But the principle of equitable and reasonable use is really unique to international water law. Of course, equity as a larger concept is not unique to international water law. You also find it in the UN Convention on the Law of the Sea, concluded in 1982 at Montego Bay. Article 83 refers to equity in the delimitation of continental shelves between states with opposite or adjacent coasts. So equity is not unique to international water law, but the principle of equitable and reasonable use is. So this is a difficult slide for me because you have to understand the equitable and reasonable use principle is very vague and generally formulated in general terms rather. And this is not because of bad drafting, but that is done deliberately to give states enough leeway, enough flexibility to apply it and to adjust it to the peculiarities of the circumstances surrounding the specific watercourse. But because it is so vague, and because the UN Watercourse Convention doesn't really give us much more detail, it is very hard to explain what it means. But I will make an effort anyway. So it's the equitable and reasonable utilization principle. And equitable and reasonable is not like peace and security when it has no independent meaning. It really, equity and reasonableness really mean different things. And taken together, they constitute the equitable and reasonable use principle. It's easier to begin by focusing on reasonable. So what is reasonable use? It follows a bit the meaning in ordinary language of the word reasonable. So reasonable use of a river, that is the best possible use of the river, taking into account the development of the state and established cultural practices of the state and of its people. The reasonableness of a particular use can be assessed individually without comparing it to other competing uses. And that is why or how it distinguishes itself from equitable use. So it's best, the easiest way to understand it is reasonable use is assessment of the quality of each individual usage of the river. And then equity comes later when you take all these different uses together and you try to come up with a balance. So which kind of uses of a river are unreasonable, regardless of what other uses there are of the river? Can anyone think of an example? What would be an unreasonable use of a river? And then think of usages for which there is a much better, less polluting, less damaging alternatives, or uses of a river that are not essential to either the economy or the social interests of the state. Those kinds of uses are unreasonable. Anyone have an idea? Well, there are some obvious examples, like a corporation that is dumping chemicals in the river, or a company that decides to take enormous quantities of water from the river to sell abroad, so not to provide its people with access to drinking water, but just to sell it abroad. Those would be unreasonable. Also, uses that have a clearly less polluting alternative. So nowadays there are other ways to cool factories that require much less water than in the past. And for example, in the Netherlands, corporate or factories that use water and pollute this water, they must treat the water first before they dump it in the river. So they must take out the most harmful chemicals first before they can introduce it to the river. So if they would not decide not to do so, they just dump the highly polluted water into the river, they would be acting unreasonable, regardless of other ways in which the river is used. So equitable use is very different in the sense that it doesn't look at the usage of, it doesn't look at specific usage of the river, but it tries to look at the bigger picture. So it takes all the different uses of a river together and tries to balance them. It does that mainly by comparing the uses in one state with the uses in another and trying to achieve an equitable inter-state balance. And equity is not equality, as I said earlier. So it's very possible that an equitable utilization in practice means that one state is using the river a lot more than the other. So how to explain that? Well, if for example the downstream state has no other source of water than this river, and if it's a very dry state, I think of Egypt. Egypt is entirely dependent on the Nile. If the Nile would cease to exist, Egypt would cease to exist. I don't know if any of you have ever been to Egypt. So everybody lives near the banks of the river of the Nile. When I was young, I really liked to read about ancient history. So all of Egypt's civilization is linked to the Nile. I mean, there's references of the Nile in tales, in stories that date date back to long time ago. So the entire Egyptian culture and history is based on the Nile. Yeah.
For the interest of states, I think it's not certain what can be for interest of an state in this world, just balance of interest of all states.
Yeah.
What can be for a state's interests?
Yeah, that's a complicated question. So, of course, the interests of the state are in. There are two kinds. They have economic interests and they have a social interest. So, social interest means every state has the obligation under international human rights law to provide access to sanitation and to drinking water to everybody on its territory. So that to be able to satisfy those basic human needs is in the interest of the state. That's an obligation the state has. But also to ensure prosperity and to make money. The state also has an interest in allowing corporations to use the water, for example, in agriculture, to make food, or to produce, well, almost anything. And many of us are wearing jeans, It takes a lot of water to produce one pair of jeans, fresh water. So the state should be able to provide this resource to factories that are situated on its territory. So that's a bit the interest of the state. So the interest of the state kind of equates with the interest of its people, more or less. Yeah.
And then there are two interests, social and economic interests.
Yeah.
I think there is no interest, I think it cannot be reasonable. Is it true?
Sorry?
If there is no interest for social and economic, this means it's not reasonable.
Yeah, that's a good way to, if that helps to make things clear, I think that's correct. Well, I forgot cultural interest. That could be a third. We discussed that earlier. So if a river has or a lake has a particular cultural significance for a state or its population, then the preservation of that river is also in the interest of the state. And you should see economic interest in a large sense. So many states also make a lot of money out of tourism. Think again of the Nile. So then the state has an economic interest in making sure that the Nile retains its attraction to tourists, for tourists. Sorry. So it's not only used by big corporations, but also tourism. So equitable utilization, the aim is to allow both states to make maximum use of the river without sort of over-exploiting it. So historically, equitable use was mainly about equitable, that is a fair apportionment of water. But to see equitable use of freshwater resources as an issue of apportionment, I find that very misleading, because then you often think of this metaphor, the pie metaphor, so you equate fresh water with a big pie made of water and then you divide it equitably. That's a bit misleading, I think. So today equity is about both the quantity and the quality of the water, about prevention of pollution and making sure everybody has access to water, at least to secure its most basic freshwater needs for drinking, food and sanitation. So how do reasonable and equitable utilization relate? So first, if you look at all the uses of the river and you exclude those that are unreasonable, then you're left with lots of different reasonable utilizations of the river. But they might, if you would allow all of them, they might lead to over-exploitation. I thought I had sneezed. Can you remove this from the recording? I'm just kidding, you can leave it. Yeah, so if you put all those reasonable uses together, you cannot just allow all of them, because that would lead to over-exploitation of the river. So there's where equity comes in. And then some reasonable uses might be excluded altogether when they lead to a disproportionately or unfair demand on the river. And so if, I don't know, if two states have to choose between satisfying the basic water needs of people in a particular village and have to measure this against the importance of the interest that a corporation has in causing slight pollution to the river to make its power plants function, then maybe the latter's use would be considered inequitable. It's important to remember that what is equitable or reasonable today might not be equitable or reasonable tomorrow. So we are continuously making innovation. And so one type of usage of a river that is reasonable now might become unreasonable when there are less polluting or less thirsty alternatives. One big point of contention is that some cultures, indigenous peoples or other traditional peoples, they sometimes have been using the river in what we now would call an unreasonable way. But they insist on using the river in this way because it's sort of part of their cultural practices. And this is a really contentious issue. So some people believe that we should have some lenience for this kind of uses of the river. But other people say, no, you cannot use culture as an excuse for unreasonable uses of the river. So even those cultural practices, if they can be replaced by less polluting or less extractive practices, then they must be so replaced. But there are others that disagree. Yeah? I hope it's a bit clearer now. Maybe it helps if I tell you that equitable and reasonable use is sometimes almost equated by proportional use. So equitable and reasonable utilization basically requires allocation of rights in the uses and benefits of shared water resources on the basis of a sort of distributive conception of equity, almost distributive justice type of argument. And having regard to all relevant factors, meaning that users and benefits will be shared in proportion to each basin's state's needs. So that means that use of an international watercourse by one watercourse state, no matter how beneficial it might be to it, would not be permitted where it would result in a grossly disproportionate adverse impact on the social, economic, developmental or environmental requirements of the other watercourse states. And so you can approach the issue in terms of distributive justice or proportionality, if that makes things clearer. It's not a mistake, I think. It's just a different way of saying almost the same thing. And the equitable and reasonable use principle has both a substantive but also a procedural element to it. That's this bullet point. So how can equitable and reasonable use follow an equitable and reasonable procedure? Well, it comes down to that watercourse states shall participate in the use, development and protection of an international watercourse in an equitable and reasonable manner, which means in practice that states must take all reasonable measures to facilitate meaningful and effective participation of other basin states in cooperative institutional mechanisms. So basically, if the two states sharing a watercourse, if they constantly cooperate with each other, if they consult each other, if they keep each other informed, if they establish joint institutions, cooperative institutional mechanisms, then it's almost impossible for one state to breach the equitable and reasonable utilization principle. So the more advanced the participation methods are, the thicker they are, and the harder it is to breach the equitable and reasonable use principle. But if both states sort of make policy in isolation, then yeah, that will much sooner lead to inequitable and unreasonable use. So this is how the equitable and reasonable use principle ended up in the UN Watercourse Convention. It's Article 5. So the aim of equitable and reasonable use is to reach an optimal and sustainable utilization of the river and its benefits. So optimal use refers to, and I just read from the slide, refers to achieving greatest possible satisfaction of all states' needs while minimizing the detriment to the needs of the other states. So it's about balancing the different river uses. But the idea of optimal use is also that you do think of ways to make optimal use of the river. And so we really try to take out everything from the river that we can possibly take out of it. And so this has very little to do with this idea of stewardship, that we just enjoy the beauty of the river from afar, but we don't touch it. No. Optimal use is really use the river. It's there to be used, so use it. There's almost an obligation to do so, to look at ways to use the river. And if you think again of Ethiopia, Ethiopia is insisting a lot on this optimal use principle. They say, well, up to now we hardly use the river, and now we think it's time to change that and to really benefit from the fact that we have the river now in our territory. And that's why they built the great Ethiopian Renaissance dam. But that seems to conflict a bit with sustainable use. Because optimal use seems to suggest that we now take everything and we fully exploit the river until, to put it a bit bluntly, there's nothing left. But there's also a reference in Article 5 to sustainable use, and that could be defined as achieving greatest possible satisfaction of the needs of the present generation while minimizing the detriment to the needs of the future generation to do the same. And so optimal use has to be balanced with the interest of future generations in also making optimal use in the river once they are born into this world. Future generations are not little children. Future generations are people that do not exist yet. Little children are part of the present generation, and they have a human right to water and so on, exactly like we do. But there are also infinitely many future generations that will follow us. So we have to use the river in such a way that we do not make it impossible for them to also make use of the river once they come into existence. So in the balance of these different freshwater uses, they're basically all, Article 6 consists of a non-exhaustive list of various uses of freshwater courses. But there's one that prevails over all the others, and that is the need to satisfy vital human needs, read the need to ensure that all people residing on your territory are provided with sufficient food, water, and sanitation to survive. Basically, the most important obligation upon states is to provide sufficient water to its people to sustain human life. And that includes drinking water, but also water required for production of food in order to prevent starvation. As I said earlier, about 70% of the water is not used for drinking, but for production of food, so that makes it very important. And here, human right to water comes into play. I don't want to say too much about the human rights-based approach to water, because I wanted to focus on the International Watercourse Convention. But let me say a few words about the international human right to water. You won't find anywhere an explicitly formulated human right to water. It's not in any international human rights covenant. But the Committee for the Economic and Social and Cultural Rights, based in Geneva, issued a general comment a few years ago, a considerable number of years ago, recognizing the human right to water as a so-called derivative right. So it's not specifically mentioned in the International Covenant on Economic, Social and Cultural Rights, but it can be derived from mainly the right to an adequate standard of living. And that's Article 11 of the International Covenant on Economic, Social and Cultural Rights. Because, that's the argument, you cannot secure for yourself an adequate standard of living if you are not provided with water to meet your basic food, drinking and sanitation needs. Providing sufficient water to satisfy vital human needs is a due diligence obligation. So states must do their very best to satisfy the vital human needs of all people residing on their territory, including people that are not of the nationality of the home state. So that also includes asylum seekers and migrants, tourists, anyone. And so the human right to water also applies to those more vulnerable groups. But if the state does its very best to secure for everyone on its territory sufficient water to meet or to satisfy vital human needs, and it fails to do so, then it has not breached any international law, because it's a due diligence obligation. It's an obligation of conduct and not of result. So, on the equitable and reasonable use principle, there's one very famous case of the International Court of Justice, that's the Kapčíkovo-Radimárus case. A case between Hungary and Slovakia, and it relates to a dam constructed on the Danube. So here you see the Danube. It's it functions here as a border river between Hungary and Slovakia. In this dam project, it consists of two parts. So you have a Radimárus dam here, and you have the Kapčíkovo dam here. So the Radimárus dam is built in Hungary, in Hungarian territory, and the Kapčíkovo part is based in Slovakia, on Slovakian territory. And these two dams, they need each other to fully function. So, Hungary and Slovakia, they concluded a treaty on the construction of this joint dam project. But then Hungary refused to build its part of the dam. So Hungary refused to build this Radimárus dam. Because, well, it has a lot to do with the politics of Hungary. It basically shifted from a communist state to a capitalist state, and these grand infrastructural projects, they fit better with the communist state. That's the main reason why Hungary wanted to rid itself of this dam project. But the treaty was made, so Hungary committed itself to building the Radimárus dam. So then Slovakia decided to build a dam by itself. So Slovakia started to build the Kapčíkovo dam, even though it knew there would never be a Radimárus dam. So the Kapčíkovo dam would not function properly on its own. When Hungary found out that Slovakia was building the Kapčíkovo dam, it wanted to terminate the treaty, the bilateral treaty on the dam. It was so angry it did not want to have anything to do with this dam project anymore.
So,
yeah.
Will we have a break?
in 5 minutes? Yes. In constructing the works, which would lead to the putting into operation of this Gabčíkovo dam working in isolation, the court, because it was the dispute over the dam went to the ICJ, the court concluded that Slovakia had not yet acted unlawfully, but it did breach the treaty when it diverted the waters of the Danube into the bypass canal in October 1992. So, to make this Gabčíkovo dam work properly, Slovakia had to divert the course of the river Danube a little bit, and that was in breach of the treaty between Hungary and Slovakia. So why is this an interesting case? Because, well, it's mostly about the treaty, but it's also the treaty between Slovakia and Hungary, but it's also about the equitable and reasonable use principle. Because in view of the International Court of Justice, and now I quote, Slovakia has deprived Hungary of its right to an equitable and reasonable share of the natural resource of the Danube, with the continuing effects of the diversion of these waters on the ecology of the riparian area of the civic coast. So by diverting the course of the river to make the Gabčíkovo work in isolation, Slovakia has acted in an inequitable and unreasonable way towards Hungary. So here you see one ICJ case in which the principle of equitable and reasonable use is applied as customary. So before we take a break, I just want very briefly to return to the treaties that we started our story with, the treaties on the River Nile. So first, the oldest treaty. So does this treaty refer to the equitable and reasonable use principle? Well, what do you think? Here, not really, huh? So then here, maybe? No, this is more about the no harm rule that I will discuss after the break. But in the more modern treaties, the cooperative framework, which is not enforced because Sudan and Egypt don't want to ratify it, you do have lots of references to equitable and reasonable use, and also to the goal of attaining optimal and sustainable utilization, and thereby to ensure equitable and reasonable share in the beneficial uses of the water resources of the Nile River system to all the states concerned. And then in Article 4, Part 2, you have a whole list of factors that play a role in coming to an equitable and reasonable division of uses. And here, last slide, you have the Declaration of Principles on the Grand Ethiopian Renaissance Dam. And here, so that's the treaty that regulates specifically that dam. And here too you find references to equitable and reasonable use principle in the second bullet point. So you see that these general principles, they do feed into more specific agreements, especially the more recent ones. It's sort of interesting that in this list of factors that play a role, there's also references to certain factors that you don't find in Article 6 of the of the UN Water Course Convention. And so there, the principle has been adjusted to the peculiarities of the Nile issue and the great Renaissance issue. Yeah, it's actually a good idea because I'm starting to lose my voice a bit. That we take a small break. How long?
We should go to lunch at 13, so how long would you want to give us a break?
What time is it now? So maybe 15 minutes?
Okay.
And then after the break we only have about 40 minutes and then we go for lunch.